Okay, excellent. I think we have Mr. Griffin. I see you, sir, and I see Mr. Jordan. Very good. And we're ready to proceed then with Tampa Electric Company versus Donald Gansner. Just remind you both, you have 20 minutes aside, and Mr. Griffin, as the appellant, you could reserve up to 5 minutes for rebuttal. Let me know, and I keep track of the clock right here. If you're ready to go forward, please proceed, sir.
Thank you, Your Honor, and may it please the court. I'm Adam Griffin on behalf of the appellant, Tampa Electric Company. May I reserve 5 minutes for rebuttal, please?
Very good, sir.
Tampa Electric is the statutory employer of Donald Gansner and James Carter, the appellees in this appeal. Under section 440.101B, a statutory employer is a contractor who sublets any part or parts of its contract work to a subcontractor. The employee of a subcontractor who is injured while performing that contract work, the statutory employer must ensure the payment of workers' compensation to that employee, regardless of fault, and in exchange, the statutory employer cannot be sued in negligence. Through its tariff, Tampa Electric has a contractual obligation to use reasonable diligence to supply consistent electricity for its customers. That the tariff is a contract between a utility on one hand and its customers on the other hand is established by the precedent of the Supreme Court of Florida, this court, and it has not been challenged in this appeal. In fact, it has been conceded. Therefore, Tampa Electric is a contractor under the statute. Now, Tampa Electric fulfills its contractual obligation to its customers by producing power at its power plants. Carter and Gansner work for Zachary Industrial, which is an industrial services subcontractor of Tampa Electric's, who maintains generating equipment at Tampa Electric's Big Bend power station. Zachary Industrial is resident there. They have on-site administrative and managerial staff, as well as mechanics. Both men were injured on the job inside Big Bend station while preparing to perform work on generating equipment. Both men have received workers' compensation benefits for their injuries, which is their exclusive remedy against Zachary as their employer and Tampa Electric as their statutory employer.
Mr. Griffin, indulge me with a 30,000-foot view down. It strikes me that your position would make anyone who is in a service, retail, hospitality, utility industry, there is no one who would not be a statutory employer.
No, I don't think that's correct, Your Honor. I think that, so the statute says, the statute requires a prime contract, and this court's decision in Green includes all work that has a sufficient nexus to that prime contract.
And now we need a prime contract. I'm correct, there is no customer contract in the record. What you're relying on, am I correct, is the utility, the PSC tariff?
We are relying on the tariff. The tariff is in the record, and the tariff is a contract. That's established by the Supreme Court's opinion in Bell South versus Jacobs. It's established by this court's opinion in Emory Life Sciences. And also in the record, we make the point that even absent the tariff, Tampa Electric offers electricity under the terms and conditions of the tariff. The customer accepts the electricity, and then there's consideration going both ways. So even absent that case law, there is a contract, and that contract's not even in dispute. The tariff is a contract is not in dispute in this action. For instance, during the summary judgment hearing, Gansner and Carter admitted that the tariff becomes a part of the contract between the customer and the utility, and that they must provide, and they admitted that Tampa Electric must provide electric service. However, they said they don't agree that there is a prime contract that obligates them to maintain the equipment. And so that gets into the court's first error here, which was requiring the work that the men were performing to appear on the face of the contract. So with any prime contract, you have the contractor that enters the contract with the third party, and you have a host of express obligations. But there's an abundance of work that has to be performed to make up, to satisfy those express obligations. That work is included within the statute. And to go back to your question.
I'm sorry, go ahead.
Go. My concern, I think, is similar to Judge LaRosa's. You say that work is included within the statute, but over time in our case law, haven't we actually gotten away from what the statute actually says? And now we are not just talking about the part or parts of his or her contractual work, but now it's become anything that facilitates the contractual work. So aren't we moving further and further away from the plain language of the statute to the point where pretty much anything can, unless something really obvious, for example, the people who mow the lawn outside of the TICO facility, clearly they wouldn't be included. But apart from that, where do you draw the line?
Well, I think the line has been drawn. The line has been drawn by this court in Green versus APAC, as well as the courts from around other courts from around the DCA. The statute. I don't think we're getting away from the text and the purpose of the statute. The statute requires any part or parts of contract work, and the word contract, the phrase contract work is general words. And under the case law, the 4th DCA and Lindsay says general words are to be given their full and fair scope, and they're not to be the courts aren't to apply ad hoc exceptions to that scope. And that's what the court has done here. It's requiring that this work appear on the face of the contract, and it's created this sort of regulatory exception that we've talked about in our brief. But I'd like to get back to this question about, is this unlimited? It's not unlimited. There is no breadth exception in the statute. And the thing we need to look at is what are the express obligations of the contract, and then what work is being performed in the furtherance of the contract. And yes,
Mr. Griffin, excuse me, you keep talking about the contract, but I don't have the customer contract in the record. We have the tariff, which is a regulatory obligation upon utility. It strikes me that may be a contract between the PSC and the utility, but I'm absent the customer contract in the record. I'm just wondering if we have a gap.
You don't have a gap, Your Honor. The tariff is a contract, and what is in the record, even in it, the tariff is a contract under Bell South versus Jacobs and under Emory versus Life Science, and it is in the record. And the obligation is clear. It's to use reasonable diligence to provide consistent electrical service. That's in the record. But more importantly, the court doesn't need to get to that here. That has been conceded. That the tariff is a prime contract has been conceded in this case, and it's never been challenged. The court, for the purposes of this appeal, can assume that the tariff is a prime contract. And going back to this unlimited scope issue, the case law makes clear that, for instance, this court in Green versus APAC, there was a question of fact about whether the asphalt being delivered to the contractor's mixing plant was in fact tagged and was going to go to satisfy the contractor's contract with the FDOT. And if it was going there, it would have been contract work. If it wasn't, it would not have been. And so the court in Green uses general words because every specific contract and situation cannot be predicted, and it depends on the facts of the case. But here you have a prime contract to supply electricity, and the work these men were doing was right at the heart of that contract. They
Let me-
were
if I may, Mr. Griffith, if you, to follow up with the discussion, I guess in my mind, I'm framing the question, did TECO owe a contractual obligation to its customers to provide maintenance on this specific power plant? And I guess that's a question that for me, because you're doing overbroad, you're claiming statute of, well, we're dealing with one power plant, this power plant. I'm sure there's other power plants involved. So are we able to respond to that question in the context of whether or not it is a statutory employer?
And sure, so from a practical standpoint, traditionally with contracting, you contract the means and methods to the expert contractor to decide how to do the job. And how they do the job is not, as the third DCA says in Pais, it's not the customer's concern. There's always different ways to do the job. And what this court recognized in Green is that the contractor has the ability to choose how to perform that job. In Green, the contractor chose to mix its own asphalt. The contract was to pave a roadway. The contractor in Green could have sourced its asphalt from wherever it wanted to. It could have purchased it on the open market, but it chose to mix its own asphalt. And the same thing is true here with Tampa Electric. Tampa Electric could have gone and purchased power wholesale to satisfy this agreement. And they could, and in fact, they do produce at other power plants, but it's within the contractor's ability to choose how to perform that work. And that's the holding of Rodriguez versus Broward County in the fourth DCA, as well as Hierro versus Miami-Dade County in the third DCA. In both of those opinions, the subcontractor was injured while performing maintenance on equipment that was used to fulfill the obligations of the prime contract. And in Rodriguez specifically, Rodriguez rejects the argument that the maintenance work must appear on the face of the contract. So in order to determine whether work is contract work, we have to look first at what the express obligations are of the contract. And then we need to ask what work is the work in issue going to fulfill those express obligations. And maintenance of generating equipment is right at the heart of that express obligation. And again, this isn't limited in scope. As Judge Yoakum pointed out, a landscaper at the power plant, that might not be work with a sufficient nexus to supplying electricity. The same would be true of landscaping at Tampa Electric's offices. But here, in this case, the maintenance on the generating equipment goes right to the heart of the purpose of the contract. And so the court, the trial court, said that the prime contract was not a qualifying prime contract under Section 440.10 because it did not express on its face the maintenance obligation, but it did not need to. And the second error with the trial court is that they basically said there's a regulatory obligation to maintain this electrical equipment. And because there's a regulatory obligation, that basically snuffs out any contractual, any work that was doing in performance of the contract. But that's not the law. That idea has been rejected by the Florida Supreme Court in Gator Freightways, and as well as opinions from around the state, including Woods, Raybon, and Mathis, all of which make clear that the obligation cannot arise purely from a statute. But I would like to go back briefly and just reiterate that the tariff is a contract under the case law, but that's not an issue in this case. That has never been challenged in this case, and for the purpose of deciding this case, the court can assume that the tariff is a contract. The third question I'd like
No, I just want to let you know you have 1 more minute to your rebuttal. I was just looking at the clock right now. That's all.
1 more minute until my rebuttal.
Rebuttal, correct. That
Thank
means
you.
Yes.
Thank you. So I'd like to touch on the third issue. When this court relinquished jurisdiction to clarify the order on appeal, we went back to the trial court, and the trial court identified a fact question here of whether at the time of the accident, the plaintiffs were performing work under a contract between Tampa Electric and Zachary Industrial. And, you know, with the big picture here, these guys are working in a secure power plant. They admit in their complaint and in request for admissions that their employer, Zachary, was hired by Tampa Electric. They were working within the scope of their employment. They received workers' compensation benefits after all. They were not volunteers, and they've never, they've never said that they were trespassers inside the plant. And so under what authority were they in the plant, if not a contract? Neither the orders on appeal nor Gansner and Carter have ever said, but the record is clear. Tampa Electric entered agreement GS 23708 with Zachary in July of 2008. That 108-page subcontract is in the record, and it's authenticated by the affidavit of Mark Hornick.
And Mr.
Zachary,
Griffin, now you're getting into your rebuttal time, sir. Just want to make.
Thank you. Zachary was to provide labor and supervision to perform on-site mechanical and electrical maintenance under that agreement. Now, that agreement required that the work was going to be assigned by a work order, but that agreement alone governed the men's mere presence inside the plant. But Tampa Electric has established the work order. Work order 2645509 expressly requires the men to perform, to clean the condenser inlet tunnel and close the access door when they are finished. And that's the work the men were doing when they were injured. This work order governed the work is established by Ronald Kennedy's affidavit, Ronald Kennedy's deposition testimony, Mark Hornick's deposition testimony, and the testimony of Robert Fitzpatrick. There has been no conflicting evidence submitted in the record to dispute this point. Finally, I'd like to mention really briefly the opinion of Jones versus Tampa Electric, in which an employee of a Tampa Electric subcontractor was injured inside Big Bend Station while working on generating equipment.
Is that the PCA?
The 13th Circuit.
Is that the PCA?
It is, Your Honor, and I'm not citing it for precedent. I'm not citing it for precedent. I'm citing it for the real world fact that we have 2 conflicting decisions from the 13th Circuit, and the men's rights and remedies at the power plant are in dispute. And so this court must reverse and uphold the statute. Thank you.
Okay, Mr. Griffin, you actually have 3 minutes left for rebuttal. I'll give you the
Thank
3.
you.
And if I could have you, Mr. Griffin, mute your mic. Excellent. Mr. Jordan, if you could, excellent. You've unmuted your mic. You may proceed, Mr. Jordan.
Thank you, Your Honor. My name is Bob Jordan from Lake City. I represent the Applees, the Gansner family, and the Carters. If it pleases the court, I'll proceed.
Yes, sir. Please do.
Thank you. Well, really, Your Honors, there are some long briefs in this case, but it's basically a simple issue. 440.10 requires that there be a prime contract and that a part or parts of that be sublet to a subcontractor. And we argued below, the trial judge found in a detailed order that there was no such prime contract. The PSC does have a tariff, and the power company is subject to the tariff. I mean, it's really a 3-way agreement between the PSC, the power company, and the customers. Now, we agreed on point 1 in the trial court that there were no factual issues. They did not include a copy of any customer agreement. And I assume they have thousands or maybe hundreds of thousands of customer agreements where people sign up for residential service. But presumably there's nothing in that agreement that would impact the issue we're talking about. They did put a couple of other service agreements in where power could be curtailed or a generator could be switched over and used if needed. And all those require is basically a contract to furnish electricity. It doesn't have anything to do with this power plant or any of these facilities. So basically, the problem here is there is no prime contract for them to sublet a part of. And I kind of imagine this as if you've got a pie, and the pie is your prime contract. And in order to sublet a piece of this contract, you need to be able to take out a piece of this pie and give it to somebody. And they can't do that. Under their tariff agreement, all they're obligated to do is furnish power at a nominal voltage. They could buy that power. They could build a nuclear generator. They could put up solar panels. They could do any of these things, but they're not obligated to operate or maintain the station. And they're so-called prime contracts. If you're talking about customer contracts, they come and go every day. I mean, there are hundreds of contracts. New people sign up, old people leave. So there really is not a prime contract. I would like to basically spend most of my time talking about 4 cases, 2 from this district and 2 from the first district that are very closely on point. The first one is the Green case. And that's Green versus APAC. In the Green case, APAC was a large road contractor who had their own asphalt plant, and they required oil and input products to make it. One of the delivery people that they bought the oil from was injured while he was delivering a load of this liquid asphalt, and it went into tanks. That case, which Judge LaRose wrote the opinion in, got reversed because they couldn't show that asphalt was going to be used for the DOT project, for which there definitely was a contract or prime contract, or whether it was going to be used for any of their other customers that bought asphalt. If what Tico has argued in this case is true, it wouldn't have mattered. It wouldn't have mattered in that case, because whether they sold under contracts to their customers or whether they sold under a contract to the DOT, they were still selling under a contract. I think Judge LaRose said early on in the arguments, if Tico's position in this case is correct, the exception will swallow the rule. There is almost no business that has customers that can't say we have contracts with our customers. I used in my brief the example of a law firm. A law firm has to buy paper. If someone is delivering a load of paper and they fall and hurt themselves on the premises, under his analysis, I could say I have prime contracts with my clients to deliver legal services. In order to deliver those, I need paper. In order to get the paper, this delivery boy came and he was hurt, and therefore I'm his statutory employer. Well, that clearly can't be right. Because
well, Mr. Jordan, as I understand Mr. Griffin, he does say that there is, I guess, a substantial nexus or a significant nexus. So, I mean, it's not completely unbounded. I guess I would have a question as to how much is a significant nexus.
Well, I mean, in a law firm example, maybe today paper is not important, but in the old days, having paper in a law firm would have been important. And if we go back to your opinion in the Green case, Your Honor, if what he's saying is right, these people who bought ready-made asphalt from APAC would have also qualified as prime contracts. So it really wouldn't have, you reversed in that case because it had to be determined whether the oil was going to be used in the DOT asphalt or the other party's asphalt. You wouldn't have had to go through that analysis if what he's saying is right, because all of those things are contracts. APAC could have said, we sell asphalt to ABC Paving Company. And in order to generate that asphalt, we have a plant. And this man was injured bringing oil to our plant. So, the analysis you went through would not have been necessary, had what he's saying been the case. The other case from this district that I'd like to talk about is the Ryland Homes case. In that case, Ryland was building a townhouse development of, I think, 60, 70 townhouses, and a man who was an employee of a contractor was injured badly. And in that case, Ryland claimed that they had immunity as a statutory employer, and they said we have 2 contracts for the sale of these units near where he was working, and therefore these are our prime contracts, and we've subcontracted it out to a framer who contracted it out to this man's employer who was doing sheathing on the roof. And this court rejected it and said, no, that's not a prime contract. You, Ryland, were building those homes. You started building them before you had contracts. You would have continued building them if you didn't have contracts. And so this is not a situation where you had a contract to do work for someone and have sublet part of it. So if building a townhome and having the part of it sheathed is not sufficient to be a subcontract, neither would this be. Now, there's two other cases I'd like to talk about briefly from the first district. The first one is the Raybon case, which involved a Holiday Inn here in Lake City, coincidentally. And in that case, the Wells Fargo was employed by the Holiday Inn to do security work. One of the employee that was injured was an actual employee of Wells Fargo. And in the course of her work on the Holiday Inn premises, she was injured. She made a claim against Holiday Inn, which the trial judge granted summary judgment and said, Holiday Inn, you are a statutory employer because you had contracts with your guests that required you to provide a secure environment. And in order to provide that secure environment, you contracted with Wells Fargo, and this lady came in to do part of the work. On appeal, the first district rejected that and said, no, that's not a prime contract. You, Holiday Inn, have a duty as an innkeeper. You have a common law duty to keep your premises safe for your guests, and therefore you're not subletting a part of your prime contract. You're simply doing your statutory and common law duty to keep the premises safe. Just like in this case, there's a regulation, and when we cited in the brief, that requires TICO by PSC regulation to maintain their equipment in a safe condition. Their duty doesn't arise from any contract they have with any customer. In fact, their contracts they've produced are silent about maintenance. There's nothing there. Their duty comes from a PSC regulation. So just like in the Holiday Inn case, it doesn't flow from the contract. Then more recently, I think in 2016, the first district also decided a case involving the Nemours Children's Hospital. In that case, they had a cleaning service that was doing some kind of maintenance, and the person was injured. So that person makes a claim against Nemours for negligence in the premises. Nemours also claimed that they were a statutory employer and therefore entitled to immunity. And the trial judge granted the motion. On the appeal, the first district reversed it, citing Raybon, mainly that their duty did not arise because of a contract that they had with anybody. It arose because of their common law duty to keep their premises safe and clean. And just like in this case, where TICO argues, oh, we have customers, and that's our prime contract. The hospital in Nemours said, we have patients. They're our prime contract. And in order to provide medical services and hospital services, we got to keep our hospital clean. Same way in the Holiday Inn. The Holiday Inn says, we have guests. We have to keep our premises safe for the guests. So the guests were what they argued as their prime contract. And in both of those cases, the court rejected it. I suggest in this case, there's really not a lot of difference. TICO is supplying power to a bunch of customers, and there's no question they have contracts with those customers. I mean, they're not giving the power away for free. But those contracts don't require any kind of maintenance or any kind of specific facility. And therefore their duty doesn't flow because of the contracts with their customers. It flows because of either their common law or their regulatory approval. So we don't have a pie where they've carved out a slice and said, okay, oh, Zachary, you're gonna perform this slice. Basically, if you allow them to have statutory immunity in this case, as a statutory employer, almost every business will get it in almost every case. I mean, even the lawn example, it may be a stretch, but you could certainly hear a company come in and say, well, we have to have a neat, safe lawn or our customers won't come to us. If we let it grow up in weeds, and therefore we're doing this in furtherance of our business. And what Tampa Electric really is saying in this case is anytime they enter into a contract with somebody to do something in furtherance of their business, then they're going to enjoy a statutory employer immunity. And that simply isn't the law. They have to have this prime contract, and they don't have it here. If I could go on briefly to point two, point two, you don't need to reach point two if you affirm on point one. But on point two, the argument is whether or not they subcontracted anything to Zachary. They have a very detailed contract, and it is in the record. And their detailed contract requires that they assign work by a written work order and authorization. And we argue in this case, based on the record and based on what they produced, that that was not done. Now, they produced a work order from 1 month before this accident, and that work order it's in the record. And all it says is you're going to do a clean out job on these units. It says open the door, basically, clean them out, close the door. That was done. That work was done because even on the day that my client was injured, before the injury, those units were pressurized and running. That meant the door was closed. So whatever Zachary was obligated to do under that work order, which they were paid, I think, at 8 hours to do, had already been done. There is no work order that authorizes Zachary or anybody else to go and make repairs on this particular problem with the door. And the problem turned out not to be just closing the door, but it had to be repaired, and in fact was ultimately replaced with a much stronger door. So there are fact questions as to whether or not Zachary had assigned any work to, whether TICO had assigned any work to Zachary. And without that assignment, there would not be any subcontracting, even if there were a contract. The final point on point 3, I will basically stand on the brief there because that case from 15 years ago or so does not have any precedential value, shouldn't have been cited down there. It isn't necessary to talk about it here. If we all agree this is an important issue for our clients, and that should be the basis of the court considering this case, not what was done in a per curiam affirmed without opinion decision. So if the court has no questions, I will stop for now.
Very good. Thank you, Mr. Jordan. If I could have you mute your mic, and that way I could hear Mr. Griffith. As I've indicated, you have 3 minutes for rebuttal, sir. Okay?
Thank you. I'll just start with Mr. Jordan said that the tariff was a 3-way agreement between Tampa Electric, the customers, and the state. That's not the case. In the appendix during the hearing on page 767, Mr. Jordan admits that it's an agreement with the customer, and it's not an agreement with the state. So this issue of whether there's a prime contract is just it's not in dispute here. The question is, what work is contract work to satisfy that prime contract? And the court does not need to draw a new boundary for this. The court does not need to expand on the reasoning in Green. We just need a straightforward application of Green and the cases from around the state, which unanimously hold that maintenance on equipment that goes to that is used to fulfill the prime contract is contract work under the statute. Now, Mr. Jordan keeps using this hypothetical about a paper delivery to a law firm, and I think we need to ask why. It's because he's talking about the fringes of this sufficient nexus test, but we're not on the fringes in this case. We're right at the heart of what contract work is, which is maintenance of equipment, of generating equipment. And this court doesn't need to be worried about a slippery slope here either, because like I said, we just need a straightforward application of Green. If we look around the state, there are plenty of cases where there's a broad prime contract, like the prime contracts between airlines and their customers. And the men and women who perform work on the maintenance on those airliners, they're doing contract work, even though those prime contracts don't expressly require maintenance on the equipment. And so this isn't unbounded. This is not unbounded. Yes, the tariff is a broad contract, but so are the airline contracts, and there's many other broad contracts. And the statute does not put any breadth limitation on what contract work is. To talk about Raybon and Mathis, the problem was one of the record.
Quickly, Mr. Griffin, because you only have about 40 seconds left. If you can make it.
With Raybon and Mathis, there was no prime contract at all in the record. There was nothing to fit. You could not figure out what work was going to satisfy the prime contract because it wasn't in the record. And those cases make that clear. If the holding was that the cleaning work or the security work had to be express on the face of the prime contract, then it would conflict with prior panel precedent in the first DCA of Miami Herald, and it would conflict with this court's decision in Green, which recognizes implied obligations. And so I'll just conclude by saying that, you know, we're here on a non-final order because workers' compensation immunity means immunity from suit, not merely immunity from judgment. This case has proceeded for 27 months. There has been extensive written discovery and briefing, and there have been depositions of 7 Tampa Electric employees from both the power plant and the office. This court should reverse and shut the case down and remand with instructions to enter summary judgment for Tampa Electric.
Very good. Thank you, Mr. Griffin. Thank you, Mr. Jordan. Thank you, gentlemen. So at this time, we're going to call the next case and appreciate